One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it." Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
Innovation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Thanks for joining the show. Today, our topic is how incapacity can affect a real estate transaction. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like and subscribe to our channel. You can find us on Facebook, and you can find us on YouTube. On YouTube, we are at InRem Podcast. That is at InRem Podcast. Make sure to go there, subscribe. We would greatly appreciate it. With that, we're going to go to Sean, who has our legal update.
So our legal update today is something that I've seen, discussed quite regularly on social media. And so I kind of wanted to just address it and talk about dispositions following a acquisition by an agreement for sale. So one way to acquire property from a seller, either through a subject to where the loans remain, or just maybe the seller owns it free and clear. And so you decide that you're going to acquire it by making payments to the seller over time. In that case, you enter into what's called an agreement for sale. It's a little bit different than a wrap transaction where you actually take a warranty deed and take fee simple title to the property, and in exchange you give back a promissory note and deed of trust. In an agreement for sale, the warranty deed stays with the seller, title stays with the seller, and then you basically, it's an executory contract where you agree to make payments to the seller over time, but you do not have title to the property. So in that case, you acquire the property. So if you're an investor and you acquire it, at some point you want to do a disposition. So then how do you do a disposition of the property? Well, since you don't have fee title ownership of the property and a warranty deed was not recorded conveying title to you, you can't then turn around and convey it using a warranty deed. Instead, you can do a disposition with the agreement in place three ways. So the first is with a lease with an option to purchase. So you enter into a lease with a third party buyer or potential buyer, and they will be your tenant. You enter into a lease, and then you give them an option or a right to purchase it at some future time. So that's number one. The second way to do it would be to do another agreement for sale, or some states call it a contract for deed. You basically do another one. So you say, okay, I'm going to agree to sell it to you, end buyer, upon you making these payments. And then of course, when the end buyer goes to fully perform, then you pay off your agreement for sale, and you end up you get the warranty deed, and then you turn around and give a warranty deed to the buyer. And then the third option is to, assuming you set up the agreement for sale the right way, or the contract for deed the right way, and you put an assignment clause in there that allows you as the purchaser to assign your rights under the agreement for sale to another a third party. You could assign the existing contract for deed or agreement for sale, and then you would basically take a promissory note and a security agreement. And the security agreement and promissory note would say, okay, end buyer, you're going to pay this much as part of your transaction for me assigning this to you. And the security agreement is going to be as to the actual contract itself, which is personal property, the agreement for sale or the contract for deed. And if you don't perform, end buyer, if you don't pay me as you've agreed under this promissory note, then I have a right to revoke or rescind the assignment and come back in and take back the agreement for sale and contract for deed and to perform on that and to find another, buyer or end buyer or do something with the property. So those are basically your three rights or ways to do a disposition on an agreement for sale or a contract for deed.
All right. Thank you, Sean. With that, let's get into some of the news items for the INREM podcast. Our next Creative Finance Symposium is scheduled not this Thursday, but the coming Thursday after, April 20th. Sean, why don't you give our listeners an idea about what we're going to be talking about at this upcoming Creative Finance Symposium?
Yeah, so this Creative Finance Symposium, it will be from 6 to 7 p.m. Arizona time. And you have to attend to receive the content. We're not going to republish the recording or even offer the recording to those in attendance. You have to attend, take notes. But two things happen. One, we do a half an hour presentation on some creative finance topic. In this case, it's going to be agreement for sale, which I just kind of talked about. So we're going to talk about agreements for sale and using them for acquiring property. And we're going to talk the ins and outs of that, what disclosures should be made if you're going to be purchasing it subject to the existing loans or entering into an agreement for sale with the existing loans, what terms you want to have in there for your protection, for the seller's protection. And then the last half an hour, we open it up for question and answers. And basically, this is your opportunity to ask two experienced real estate attorneys questions related to real estate law, questions related to creative finance, and we are captive for that half an hour, and we will do our best to respond and provide, legal education and guidance in response to those questions. So take the opportunity to plug in, to attend. It's online, and we will start this in the next coming days. We're going to start basically advertising and promoting the event on social media. If you follow me, if you follow Andy, if you follow INREM, and there's other platforms and groups that it's going to be posted into. But if you follow us, you can't miss it. Just jump onto our pages, take a look. It'll be there. The link is right there, and join us.
Yeah, we'll have the link on Facebook. We'll also have the link on the INREM YouTube channel in the community section. We're able to post questions, polls, as well as links to upcoming events. That's not the only event coming up. Sean, you're actually coming up here at the end of the month in a creative finance event, aren't you?
Yes. So I'm going to be appearing in person, and this is an in-person event designed for real estate agents. It's going to be Friday, April 21st, and it's going to be from 2 to 6:30 p.m. Arizona time. It's in Tempe. I've already posted information about it on my personal Facebook, so you can go there and find out. But I'm going to be speaking at a creative financing event entitled How to Legally Double Your Business Using Creative Finance. And it's basically, once again, for licensed real estate agents to learn more of the ins and outs of creative finance. My co-speakers are going to be Pace Morby and Eileen Brown of American Title Service Agency. She's a branch manager and escrow officer and done tons of subject to wrap financing transactions and is very, very knowledgeable in that arena. And it's going to be a great event. So I would encourage anyone that's a real estate licensee to come out and attend that event next Friday.
All right. Should be good. Make sure if you're eligible to take a look and head out for that. In addition to the Creative Finance Symposium, we try to make ourselves available here every Tuesday live to answer your questions as well. And as a result, we're going to be taking questions today, both Sean and I, as well as our speaker who's going to be here with us to discuss the topic. So if you have questions, I'm going to turn it over to Mayu, who can give you directions on how to go about that and interact with us.
Yep, and happy Tuesday, investors. Thank you for everyone who is joining in REM today live. That's right, you heard Andy. We are taking questions live at the end of the show. I will be monitoring the chat, so whether you're watching the show from our YouTube or Facebook, all you have to do is drop your questions in the live, and then we'll try to get to them at the last 10 to 15 minutes of the show. We only do have the last 10-15 minutes, so try to drop them as soon as you can if you want them to get answered. And like I said, we'll get to them at the end. So back to you, Andy.
All right. Thank you. Make sure to post your questions now in case you forget about them. We'll be there to answer them. All right. Let's get into the topic today. We're talking about incapacity and how incapacity can affect the real estate transaction. Remember, this is a show for real estate investors. We try to dive into the law and how your real estate deal can be impacted legally. We know probate is a big part of that. Death can be a part of it, but often not discussed. And even bigger part of it is this idea of incapacity. So we want to explore that for you. And with us to talk about that is Arizona attorney Lou Silverman. Lou is an attorney with the Silverman Law Offices here in Arizona. Thanks so much, Lou, for joining us.
Thank you for having me.
So tell us and our listeners, Lou, a little bit about you, the Silverman Law Offices, and how you got into doing what you do.
I've been in the practice of law for 43 years, and the first 20 or so was in more of the general civil litigation world. Did a lot of different kinds of civil litigation, real estate title work, which was pretty interesting work, personal injury, some divorce work. I had quite a number of jury trials back in those days. And about 2005, I decided that I wanted to narrow my practice. I felt like I was trying to be a jack of all trades, master of none, as they say. I did not like going to trial against big law firms that had, hordes of associates to be prepared, and I had to be prepared by using yellow sticky tabs all over the place and just to keep up. So anyway, in 2005, I transitioned my practice to estate planning, probate, and trust work. Basically had to start saying no to all the referrals that were coming in from all different sorts, all the different sources, and really focus on creating my relationships in the estate planning world. And lots of education to become proficient. And then I've been doing that ever since.
Now,
I was board certified by the state bar about 7-8 years ago. So I'm board certified in trust, probate, and estate planning law in general.
Now, I know you're licensed in Arizona, but you're also licensed in Texas too. Do you practice or do any work in Texas?
No, I was born and raised in El Paso, Texas, and I went to law school in Texas. So, I always kind of entertained the possibility that I might do some practice there, but I really never have, not since I graduated. So, no, my license there is just for wall decoration.
So here locally, a number of folks, including yourself, refer to you as the tie-dye lawyer. And
Right.
That shouldn't come as a surprise to any viewers right now who are
Probably
watching.
not, yeah.
And how beautifully you match your background. But why don't you give us the background on how you became the tie-dye lawyer?
About 7 years ago, I was on the big island of Hawaii, in an area called Captain Cook, which is located a few miles south of Kona. But it gets pretty rural down in that area. You don't feel like you're in any kind of a city at all. It's all farms and jungle. And so I wandered into a tie-dye shop. This guy's name was the Tie-Dye Hobo. And I watched him tie-dye, and I was just sort of fascinated by the process. And I really thought that it was, it looked fun, it looked safe, it looked harmless. And there's something about my brain, I guess it's the right brain. I can't remember which side of the brain craves that creativity and having some fun. And So I came home and I started experimenting, and the next thing you knew, I was starting to make tie-dyes and giving them away and going to markets and selling them. And so that's how that sort of snowballed to become the tie-dye lawyer. Although it's still really a garage hobby. I haven't, taken it to the road. I don't have a shop. I do have a website, tiedyelawyer.com, but it's still very much a side, small thing for me.
Well, it's clear to me visually that you've become proficient at it.
I'm getting better and better all the time. Yeah, learning techniques, and YouTube is great for self-education. I think one could learn how to become a surgeon on YouTube if you spend enough time doing it, right? So
yeah. Between YouTube and AI, what's coming, you're going to be able to do anything.
Yeah, the good news is that as we start to lose our brain function, it's not going to matter anymore because everything's going to be replaced anyway. So,
well, what a segue that is, losing brain.
No, I did that on purpose.
I know. I mean, that you couldn't have planned that any better. Leave it to the tie-dye lawyer for transitions. All right, so let's transition and let's talk about incapacity. And this subject is ripe with hypotheticals. We thought of a lot of them as we went through this, but we wanted to discuss really from the beginning for the viewer who's really a real estate investor, who's either maybe new to the space or has been in it for a long time, but may have not come up with this. Their job is to get deals done and deals closed, and that's what they do. They're real estate investors. We want to start from the beginning with trying to describe what incapacity is. And in talking about that, we realize it's actually a lot of things, but how do you, just to start, define incapacity?
Well, and I would initially rely on the statutory definitions of incapacity, because there are two very similar definitions in our probate code. One is under the conservatorship section of the statutes, and the other is under the guardianship section. Under the conservatorship section, a person is incapacitated if unable to manage the person's estate and affairs effectively for reasons such as mental illness, mental deficiency, mental disorder, physical illness or incapacity, chronic use of drugs, chronic intoxication, confinement, or detention by a foreign power, or disappearance. Subtly, the difference in the guardianship statute is basically the same grounds, but now it's to the extent that he lacks sufficient understanding or capacity to make or communicate responsible decisions concerning his person. So you have the slightly different definition. One is more related to affairs and property, and the other is related to taking care of the person.
And I take the nuance in those two definitions is due to the fact that conservatorships and guardianships are technically doing two slightly different things. Why didn't you explain that?
Yeah, the difference is that a conservator is appointed by the court to take care of the property of an incapacitated person, which could mean anything from real estate to money in the bank, pretty much anything that's property. A guardian is appointed by the court to take care of the person, to make medical care decisions, residential decisions, educational, recreational. So a person who has no property to speak of will not need a conservator. Simply, there's no reason to have one. In most cases, a guardian and a conservator are appointed at the same time, because most incapacitated people have property and they have to take care of their person. So there's a difference.
So both of those positions or those definitions rather are somewhat broad. And I think what oftentimes a lot of people think of when they think of incapacity is they think of either some sort of mental or physical disability prohibiting them from making certain decisions, which it certainly could mean that, but it doesn't just mean that only. Is that right?
Right. So, and the other confusing part of all of this is that there are different standards for incapacity depending on what we're talking about. So the standard of incapacity to execute a will or a trust is generally, I would say, lower than it is where for a court in a probate proceeding to make a finding that a person needs a guardian or conservator. The courts have been very clear, A, that there is a presumption of capacity, and B, that it takes quite a bit of evidence to overcome that capacity, or overcome that presumption. So there are cases where the description of what the individual is going through at the time that they've executed a will, and the facts that were shown in court, and yet the courts still come back and say that was sufficient to show that the test is they knew and understood the nature of the act, they knew and understood the nature and extent of their property, and they knew the objects of their bounty. So it's kind of a three-pronged test to determine if a will is valid or not. So most of these fact situations, in my opinion, are clearly sufficient that a court would have appointed a guardian or a conservator for these people, and yet a court still comes back and says that they had sufficient capacity to, execute the will or trust. So there's some conflict in there.
So what you're saying is, potentially you could have somebody that's suffering from, say, Alzheimer's or dementia, and they have, good days, they have bad days, certain times of the day they're better than others. And if you catch them on the right day at the right time, they could enter into a valid and binding contract. But at the same time, you would have legal justification for appointing a conservator or guardian if you needed to. So it's kind of, a little bit of a conflicting situation there.
Yeah, it's sort of ironic because, in fact, we will sometimes, if we're scheduling a signing and we know that there are questions about capacity, I will ask at what time of the day that person is most lucid. And typically it's morning. Although unfortunately, a lot of people with the age and, become in this stage, they're not particularly morning people. So, but it seems like morning is the time of greater lucidity where we would want to have these people sign their documents. Because we want to make sure, again, that as we speak to them, that they more or less pass the test of knowing and understanding what they're doing, knowing and understanding the nature of their property, and knowing the objects of their bounty. So if you can kind of go through those questions and you feel satisfied that they've answered them well, you can conclude that they have sufficient capacity to execute the will or trust.
Now that's a different analysis or a different process, just so the listener kind of appreciates, there's this process in court and proving it to a judge, but there's a process at a conference room table, signing documents in front of a lawyer that, Lou, you're saying as they come into your office, whether you know it coming into the meeting or whether you believe it to be true or potentially being an issue as you talk with somebody more individually, this is an assessment you need to make at the time the documents are executed, correct?
Yes, and I'm not skilled in psychiatry, so therefore there is a certain amount of, risk. And I've talked to lots of lawyers about this, and some will not, perform that kind of evaluation themselves. If they think there are questions about a person's capacity, they're going to ask the client or potential client to go see a physician and get the physician to assess and put into writing that the physician believes they have capacity. Kind of two schools of thought, because if I just ask the questions that I feel comfortable that they're lucid or they have capacity, clearly I'm not a professional in that field. I'm relying mostly that their answers make sense. And that's the best we can do sometimes.
Yeah. So is this analysis from a professional like yourself unique to the estate planning process, or or is this a process that ought to be done if deemed appropriate in the execution of any legal document?
Well, I don't think, Andy, that I would put you through that questioning. I think that I would trust that you have capacity. Sean may disagree, but that's for another story. But you have to have questions raised in the dialogue for you to have that concern. And those questions can be raised by family members, or they can simply be raised by your own, discourse and starting to sense some confusion. The same questions are being asked and answered over and over again. So I think that's just one of those, you know it when you see it, that you feel I'm starting to get a sense of discomfort that perhaps this person, doesn't have capacity, and I need to be on my tiptoes.
Now, where this is going legally, and correct me if I'm wrong, but this is really going to the effectiveness or the enforceability or the legal standing at all of the document that the person in question is signing, right? Because if they don't have the capacity, whether it's a purchase contract for real estate, a will, or a trust, it's not a valid document. Is that right?
Or it's voidable would be a better way to say it. Yeah, I would say it's valid on its face, but it's voidable because of lack of capacity.
So in your experience, what are the most common causes of incapacity that you typically see?
Going to law school would be the top that I can think of. Then beyond that, I think age is unfortunately probably the most prominent cause. And again, you're asking the wrong person for that, because I left my medical degree at home this morning. I simply know, based on my experience with my interaction with people, and it's generally an age-related issue, as opposed, if it's other things that are happening, could be medical issues, brain disorders. All of those things can factor in, but that's something that I have to be warned about. Like, my husband's 40 years old, but he's been diagnosed with, and then that kind of triggers, like, okay, we're going to be on guard here. Let's see what's going on. So.
Well, and there's one group, who just don't have legal capacity, which is minors, right? Minors can't contract at all. They can't own real estate.
Right.
If a minor wants to own real estate, they are going to have a parent act as a conservator for them to own real estate, because they can't even give a power of attorney, right?
Right. No, a minor doesn't have capacity right off the bat. So, in fact, there is a division of the probate court that is dedicated to minors. So if a minor inherits, which happens, they'll be named as a beneficiary in a will or a trust, or on a life insurance policy. And as a 15-year-old, they inherit. Well, they can't hold that asset. The financial institution won't release the asset to them. So that's where a court needs to appoint a conservator who steps into that role until the minor is 18. Then at 18, the minor has capacity and is able to, receive the property, which is often a very poor plan, by the way, because you don't generally want an 18-year-old to have immediate access to large amounts of money. But it happens, and it's kind of what happens with lack of planning. I see so many people when we're going over their assets, and on life insurance or say an IRA, they will name their spouse as primary, and then they'll name their minor children as the contingent beneficiaries. And they don't know what that's going to trigger, but that triggers some, pretty bad results if that happens.
So let's talk about the limitations of incapacity and who can make that determination. And it sounds like from what you were mentioning before, the presumption is in the law is that you have capacity. So, whether or not you enter into or whether you had the capacity to enter into an agreement may be voidable later and be determined that you didn't. But the law presumes that you had capacity. What does that process look like with a judge? Is that a formal probate proceeding in order to determine incapacity?
Yeah, it depends on where we are. What's the issue? So if it's an issue of challenging a will in a probate, then the burden of proof would be on the person challenging the will to prove that the person lacked capacity. In the conservatorship guardianship arena, it's a bit different because in that arena, typically it's either a family member. Sometimes it's somebody that's called a private fiduciary, but somebody is stepping forward asking the court to appoint them. And the courts rely on a form that's called a healthcare physician's report or healthcare professional report that the physician is asked to complete. The court doesn't want some sort of a rambling narrative that a physician dictates, that kind of goes all over the place, because it doesn't really help the court make the final decision of whether this person does need the appointment of a guardian or a conservator. So the court's form is very specific, including daily tasks that the person cannot or can do, whether they can drive. So that's how the court, generally assesses whether or not there's even a threshold met that a person lacks capacity. So the process, if you want me to walk you through the process, I can do that a little bit. So
sure, yeah, go ahead.
once you file that petition, and among other things, you have to submit that physician's report. And, you make your allegations that the person lacks capacity. If it's a guardianship only, you don't have to allege any property. There's no property that you're asking to be overseeing. So it's simply asking the court to appoint one as the guardian. If it's a guardian and conservator, then you also have to allege what assets that the person is aware of that need to be supervised. Sometimes that's difficult because, say you have an elderly parent and one of the children is attempting to assume that control, they're not always even aware of what all the assets are. So they're sometimes just the best guess, and then that's supplemented down the road. The reason that the value of the assets is important is that the court is going to require a bond. So if you're appointed as a conservator over $1 million asset, you're going to have $1 million bond, because that protects the individual who's called the ward. If you abscond with assets, you've got a bond protecting you. So some people are not going to qualify to be a conservator simply because they can't qualify for the bond. The more assets there are, the higher the bond premium as well. So you have to qualify for a bond, really just as if you'd have to qualify for a mortgage. So not everybody is going to qualify for a bond. So sometimes that just eliminates people. The court, as soon as a petition is filed, is going to appoint an attorney. So it's called court-appointed counsel. And there are lawyers that are on sort of a revolving list of approved court-appointed counsel. And you generally see these same people over and over again. So I've probably had a dozen cases with the same court-appointed lawyer over the years. And in one case, there's a law firm of 3 or 4 brothers, and you rotate through all the brothers and you kind of forget which brother you've dealt with at any given time. But that's how the process works. The court-appointed lawyer's responsibility is to interview the ward and, kind of investigate whether or not everything looks up and up. In some cases, the ward will be very compliant and not have any opposition. In some cases, the ward will be really so incapacitated as not being able to form much of an opinion. And then there are some cases where the ward is very adamant that they're not incapacitated and they don't require a guardian conservator. So you can kind of go any of those 3 directions.
Who pays for that attorney that's appointed for the ward? Who's responsible?
The applicant,
Yeah.
petitioner. Now, if they end up getting appointed and they have access to the ward's property, then generally that's going to be paid out of the ward's property. However, if you're not appointed and the court doesn't allow you to, that's going to come out of your own pocket.
So, how much does it typically cost then to have a conservator appointed? I mean, what are you talking about fees range
In
wise?
legal
Assuming,
fees alone, you mean?
yeah, attorney's fees, which would be the fees that are paid to somebody like you, Lou, who's going to
Yeah,
represent the applicant. Then you have to pay the ward's attorneys, court-appointed attorneys' fees. There's
right.
costs. There's all this stuff that goes on. I mean, how much are we talking? Tens of thousands of dollars?
No, not that bad. Well, it depends on the law firm. I tend to think I'm probably on the lower end of the cost structure, but we would generally estimate that in a conservatorship, it's going to be about $3,500 for the fees and costs, and then the cost of the court-appointed lawyer is an addition to that. And then, if it gets contested, it's kind of hard to predict, as you guys know in your line of work. If anything that becomes contested becomes unpredictable. You don't know who you're dealing with. You don't. Some other counsel can be very easy to work with and try to get to a good result. Some not, and so it's really off the charts in that situation.
So yeah, when it's all said and done, when you pay the applicant's attorney's fees, the ward's attorney's fees, the costs, and if it's uncontested, you're probably looking 6 to 7 grand.
I
In
think
attorney's
in a
fees.
conservatorship that would be true. In a guardianship, I would tend to kind of go a little lower than that, simply because in a guardianship you don't get it at all involved in assets. You don't worry about assets. You don't need to get a bond. So the whole process tends to be a little simpler in a guardianship. But if it's contested, you're going to end up with the same problem, which is
Right.
having to either drop it, or the ward's going to go out and have their own physician. So there's all sorts of ways that could go.
So, our show is focused on real estate and investors. And we'll get to the problems that come up in a minute about incapacity. But a guardianship wouldn't do anyone any good if they're trying to sell real estate.
No,
Right. You would have
no.
to have
Guardian has very limited power to property. The guardian is allowed to receive a person's social security. So, if really all you're talking about is a monthly social security check, you don't need a conservator for that. But other than that, if there's property, you're not going to be able to manage that as a guardian.
Right. You have to be appointed as conservator. You have to post that
Right.
bond. It's a whole process. Now your experience with real estate, I mean, you have a little bit of background there. And when we talk about determination of incapacity, you have attorneys that do their best to make that determination for estate plans and things like that. You have doctors, you have judges, but there's also these real estate professionals, one of which is a title company, right? And when you're in a real estate transaction, generally you're going to be using a title company who's going to ensure that the buyer is receiving good title to the property. And there's what the law provides, such as what you dictated, Lou, which is, hey, if they're lucid, if they have a good day, a good time, they can contract and they could show up at the title company and be very capable of signing documents. Well,
Right.
the title company may say, well, yeah, that might be what the law is, but we're not going to ensure good title to the buyer if we know that they have some form of, limiting condition as far as capacity goes, right? Alzheimer's or dementia or whatever. And so you could, in theory, have a situation where you have a very simple transaction, husband and wife, and they own it, community property with right of survivorship. Everything's good. They want to sell their property. They're going to downsize. They're going to do something, and they're ready to go. And the wife informs their broker or informs the title company or whatever that my husband's just been diagnosed with Alzheimer's. We want to downsize. He can't take care of this house anymore, et cetera, et cetera. And the title company says, well, time out. We're not doing this transaction. So
Yeah.
now what are the options? How is this property going to be sold if the title company is not willing to let the wife sign?
Well,
Or the husband sign in that hypothetical, the husband sign.
Unless you can convince the title company otherwise, and perhaps you might be able to get the husband's physician to, certify that he or she believes that this person has sufficient capacity. That might be enough. But what I would recommend in a case like that is we do have, as an alternative to a conservatorship, which is a long drawn out process, because in a conservatorship, not only when the person gets appointed, do they have to, A, post the bond, B, pay the court appointed lawyer, pay their own lawyer, et cetera. But then they have to file an estate budget. They have to then every year, they have to file an annual accounting. And it's a pain in the butt. I mean, it is not an easy job. It's not a job that I would volunteer to do, I will tell you that. But the alternative is that there is a process in probate court that allows the court to appoint a conservator for a single transaction. So if we had a property in escrow, and if we could keep the deal together long enough that people are patient enough, we could file a petition for a single transaction authority. The court will appoint somebody, probably the wife, with authority to close the transaction on behalf of the husband. And then as soon as it's closed, we can file a closing statement and tell the court we finished and we're done. So it's sort of an in and out probate, a lot less expensive because we don't have any of those ongoing responsibilities. And it's a way that we can get a deal done. So that would be the way I would probably recommend if a person came to me, whether it's the realtor or the client, and saying, hey, I need to close this deal. How do I do it? That's what I would recommend.
Now, in that type of transaction or probate, is there still going to be a court-appointed attorney for the ward?
No, it's really a truncated process because all you're doing is you're showing to the court that there's a single transaction. And generally you're explaining that the property's in escrow, that the questions of capacity have arisen, and you ask the court to allow the spouse to close escrow without the husband's participation. And there's no court appointment, there's no budget, there's no accounting, there's no bond, none of that.
How long does that process take?
We can usually get that if I were filing that petition today, which means that I've had enough information given to me to be able to do that, we usually can have a hearing within 6 weeks. So if we can keep that escrow together for 6 weeks, we can probably survive.
Yeah. So the buyer just has to be patient. The sellers have to be patient, but it can get done in fairly short order as far as cost goes, and even time frame as opposed to the standard.
Yes, it's less expensive.
Yeah.
Again, it's an in and out kind of a deal. So overall, that would be the best way to go. And I've used it successfully, so it does work.
How does that time frame compare to what you'd expect in a normal time frame if a full conservatorship was required?
Well, the conservator, the hearings generally are, within 6 weeks to 2 months after you file your petition. But there's more moving parts because you've got the court-appointed lawyer who has to be satisfied that the person is in need of the appointment, doesn't oppose the appointment. And then B, you have to have a social study done for guardianship. So in a guardianship case, the court has a social wing and they send a court visitor out and they inspect the property. They want to make sure that where the person is living is safe and whatever the applicant has in mind, whether they're going to move them or whatever. So they're investigating the background. And so it's not going to happen as quickly and you have more risk that it's either not happen at all or it's going to take longer. That single transaction is usually pretty tight and you're going to get that done.
Now, what can an estate or a couple or persons do to avoid the conservatorship, the probate process entirely in the event of incapacity? Is there anything they can do?
The best thing they could do is have an estate plan. So um, if you have a trust, so I don't know if we're going to go into the whole what is a
Mhm.
trust or whether
Sure.
you want to spend that
Sure.
much
Yeah.
time. But, when people create a trust, they're creating basically an agreement with themselves initially. So the people who make the trust, we call them the grantor, the settlor, the trustor, the trust maker. Those are all the same meaning. And they agree with themselves as trustees to manage the property in a trust, and then the trust is funded. So the real estate that would be ordinarily, say, subject to a sale without a trust is held in the trust by title. So when the trust sells it, the husband and wife as the trustees would be signing, the documents. So one of the ways that a trust can avoid all of these problems is that it can have within it built-in approaches to how a person's incapacity will be handled um, efficiently without having to get the court involved. And so a trust is a great way to have property sold simply because it's, generally speaking, not going to be subject to ever getting the court involved. And the other way is that people have financial powers of attorney called a durable power of attorney, which gives a third party authority to handle, matters for them. And typically it's going to be very specific as to things like real estate transactions and banking authority and things like that. And the durable part is the most critical part of that, because what durable means is that it's valid whether or not the person has capacity. So if I'm giving you a power of attorney and it's a general durable power, I'm saying that this document is valid notwithstanding my capacity. And there's a variation of that called a hybrid, which is a springing power, which says my agent only has authority to act once it's been established that I am incapacitated. And then it will say how that's going to happen. Unfortunately, it will often say 2 physicians certify in writing that I lack capacity. Well, in my opinion, that's a recipe for not working. It's a recipe for disaster, because it's so difficult to go out and get 2 physicians to verify that you lack capacity, A, and then B, because the durable power of attorney is requiring that proof, you're now publicizing to the world whatever the doctor has put in that report, because now you're giving that power of attorney to the title company, and 2 doctors have certified that, so I think it's a very poor planning technique to require that power to be springing. But some people are not comfortable giving that power without that check and balance, so to speak.
So you bring up an interesting thought, and I'm with you. I'm not a fan of the springing power. I think it should be an immediate power, especially when you're dealing with real estate and title companies who, a title company may not even accept the form or the way the doctor phrased something, and say, well, this isn't enough. And, you don't want that. But let me ask you, go ahead.
My experience, by the way, Sean, and I imagine you guys share it, is that any time you're leaving a decision up to institution, big institution, which could be banks, financial institutions, title companies, insurance companies, they're not really on your side. I mean, they're trying to protect themselves. They're not trying to make something happen to make it easy on you. In fact, many times they make it so difficult on people, it's just, you want to pull your hair out. So yes, anything you could do to avoid giving them a veto, do it, avoid giving them that discretion, because their discretion is generally not going to be very favorable. Sorry to have interrupted you.
No, I agree completely. Thank you. That's good comments there. Now talk to us about a trust though. Do you have that same issue with a trust, meaning husband and wife, they create, your general revocable trust, family trust. They're both trustees. of that trust, but then one of them is incapacitated and the house is owned in the trust. And of course, the trust is going to have its own provisions stating what incapacity means and how
Right.
a trustee. Is there a way to plan around that?
Yes, the way we plan around that is we include in almost all of our trusts, unless the client is opposed to it, a concept that we call a disability panel. So the concept is that instead of relying on physicians to have to make the certification, the trust maker will appoint people who they rely on to make that determination. And so it could be spouse almost always, if there is one, adult children, other relatives. If they have a longstanding physician, they may include the physician. But it's the panel that certifies the incapacity, not the physician. And the trust provides that if the panel certifies the incapacity, then that removes that person as a trustee. And then we just go forward with a single trustee or a successor trustee, whoever that might be. So everything is internal within the trust that way.
All right, guys, I think we have a couple questions. Mayu, why don't you give us questions from the audience?
Yeah, okay, here they go. So here's the first one. I'm new to real estate. Well, welcome to INREM. You're in the right place. And I'm dealing with probate cases regularly. Guardian ad litem. I see this a lot. Is it similar to the kind of representation for someone that's incapacitated?
It is similar. The difference is that when the court appoints a court-appointed counsel, that person is hired to, or not hired, appointed to represent the interests of the ward and becomes that ward's attorney. A guardian ad litem is typically appointed more to assist the court in making determinations. So not necessarily to represent the interests of the ward so much, but to represent the interests of the court, to be in a position to report neutrally. Guardian ad litems are used often in family law cases where there's custody issues. Guardian ad litem could actually be appointed to represent the interests of children who the court is concerned are not getting adequate representation themselves and are kind of being lost in the shuffle. And it can be used in a guardianship or a conservatorship case, but we don't see it very often because usually the court-appointed counsel role is sufficient to represent the interests of the ward.
Interesting. Do we have any other questions, Mayu?
There's one more. This one's in regards to single transaction conservatorship. Is this a process that can be done for property and probate?
Well, if you're already in probate, meaning I'm assuming by that question that we've had a death and we've got a probate proceeding, once the personal representative is appointed, they have 100% authority to transact business on behalf of the estate, and that includes the sale of real property. So unless it's a very unusual situation, a personal representative doesn't need to go to court to get authority to sell property. They already have that authority. Now, if they feel that are uncomfortable, for example, there's questions of value. You know, the PR intends to sell property for $1 million, but the beneficiaries are arguing, no, it's worth $1.5 million, you know, things like that. Then I do recommend petitioning for approval and let the court decide, because you'll come to court, you know, you'll bring your contract. If necessary, you have the realtor testify. And generally speaking, you post that on the property, you publish in the newspaper. So you've complied with rules to make sure that anybody who's interested in that property has an opportunity to come in and bid on it. But that's not required per se. That's only to protect the parties.
Yeah, if you could compare and contrast a little bit this process between just your kind of your standard probate versus incapacity, conservatorship, guardianships, the probate process, in my estimation, is much simpler. You know,
It is.
somebody's died. We just now need somebody who can legally act on behalf of this person to liquidate.
Right. So, the probate process is simpler. Part of the reasons for that, I don't know if you guys recall or if your other listeners recall, but a number of years ago, I'm going to say more than 10, there was a series of columns by an Arizona Republic reporter by the name of Lori Roberts. And she started uncovering these guardian conservatorship, mostly conservatorship cases, where there were private fiduciaries appointed. A private fiduciary is a role that is licensed by the Supreme Court, basically to handle other people's property. And these private fiduciaries would come in and be appointed as the conservator. And she was tracking just ungodly fees that were being paid to them, that were being paid to their lawyers. There was no check and balance on the system at all. She tracked a number of cases that were just literally being fleeced. And so that led to a whole update to the guardian conservatorship approach in Arizona, which is what is now making it more time consuming, more difficult, but on the other hand, safer for the ward. But in probate, we don't really have anything like that. So if a person dies with a will and we have the original will in hand, that can be filed for probate without ever going into the courtroom or having a hearing. That's called informal probate. There's a registrar that handles all those. So if everything looks up and up, they'll appoint your personal representative. Most wills waive bond, so you have no bond, and bam, you're on your way. You got what you need. You have what are called letters testamentary. You can sell real estate. You can empty bank accounts, sell businesses, everything. It is, in fact, as the lawyer for the personal representative, have encountered more cases than I can tell you where we've lost control of our clients, because once we've gotten them appointed and they have that piece of paper that they need, they don't need us anymore. They don't report back. They don't respond to our follow-up because the court has so little oversight over them. That compares to other states where they have an incredible amount of oversight. Everything has got to be approved by the court. It's very expensive, long process, but Arizona has chosen a simpler process, which is good in a lot of ways, but it is more prone to fraud or, malfeasances in the probate area.
Well, so much of what you said makes me think that planning is such an important piece to this, because just constructing a proper, not even a complex, but just a basic estate plan could save, on one hand, if you've got durable powers of attorney, could save you just the cost of a simple document versus the cost of paying for lawyers to go into court to get a conservator appointed. So they have the ability to act on the ward's behalf.
People who balk at doing estate planning because they don't want to pay the fees are in the backside requiring thousands of dollars of fees to be paid, causing terrible family relationships, terrible legacies, because of lack of planning. It leaves everything up in the air. So, yeah, I mean, it's a valuable investment to have a good estate plan, in my opinion.
Yeah.
But of course, I would have that opinion since that's what I do.
Well, but it sounds like, too, there are some secondary options or more preferable options for the real estate investor or family who's trying to just single use sell a property where an escrow got interrupted because somebody became incapacitated for one reason or the other.
Yeah, that single transaction authority is very valuable to know about. And then also, in a case of a death, let's say you've got a contract in escrow and the seller dies, you actually have a pretty good chance that you can resurrect that deal, because a personal representative can be appointed so quickly. In a matter of weeks, we can have somebody ready to close. All the title company is going to want to see, are what's called letters testamentary. That's all they really want to look at. Once you've got those, you can sell. So
And you get
there's
that on
ways.
the front end of the probate too, right?
Yes, you can do that right. You can do that on day one.
Yeah.
Yeah. So there are a lot of ways that we can resurrect real estate transactions in the event of death and incapacity where someone would have otherwise thought that's not possible.
Well, Lou, thank you so much for your time. We appreciate it. Why don't you tell our
You're welcome.
listeners how they can connect with you and find you?
Well, our office phone number is 480-491-3216. We're located in Tempe on the corner of Rural and 60 by the Embassy Suites Hotel. And then lastly, it's Lou, L-O-U, at Silverman Law, P as in Paul, C as in Charlie, silvermanlawpc.com.
And if you ever see somebody selling tie-dye at the local art fair in Tempe, it's probably Lou, right?
Well, actually, last weekend was the big Mill Avenue Art Fair, where they get hundreds of merchants, and I found 4. So it's probably not me. These are people that are traveling around the country making their living selling, tie-dye art. So
yeah,
lot different than my situation. Maybe in a few more years you'll find me. I'll have my ponytail and the whole bit.
There you go. Well, thanks so much for being with us.
Thanks for having me. I appreciate it.
Yeah, look forward to doing it again. We'll see you next time.
Bye-bye.
All right, everybody, that is our show. Thanks for joining us this week. Make sure to join us next week. We're talking about subject to transactions, doing sub 2 tax-free. We're going to be talking with attorney Jeff Watson. Look forward to seeing you next week. Have a good one.
Have a good day, everyone.